Hello, and welcome to In the Privy Council, a podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week we're discussing the Mauritian case of Pyaneandee and Shang Leen, the citation for which is 2024 UKPC 27, MRC. As a reminder, because Mauritius is a republic, this case is decided directly by the board, rather than by His Majesty. This case concerns how and when the decisions of a public inquiry should be amenable to judicial review. For the purposes of our discussion, the relevant facts are as follows. Mauritius established a commission of inquiry on drug trafficking, designed, as one might expect, to inquire into the problems of illegal drug trafficking in Mauritius. Among the many witnesses called over the 3 years during which this commission was working was one Mr. Pyaneandee, a barrister at law. Various questions were put to Mr. Pyaneandee regarding alleged visits he had made to an imprisoned drug trafficker. In the ultimate report of the commission, Mr. Pyaneandee was included in a section called Black Sheep, which detailed various barristers alleged to be associated with drug trafficking. The report was very critical of Mr. Pyaneandee's alleged visit to the imprisoned drug trafficker and made some strikingly phrased conclusions. To quote, in part, "Was he acting as a spy for other more important drug dealers, and the danger of such visits already pointed out by the Commission? The Commission recommends that an in-depth inquiry be instituted to look at the role of counsel, which seemed to have tried to pervert the course of justice and trying to shield traffickers." As one might expect, Mr. Pyaneandee was not happy with these conclusions and commenced judicial review proceedings of the inquiry, arguing, inter alia, that the Commission had failed to consider contemporaneous statements he had made to the police and investigating teams about his visits, and the various matters and allegations in the report's conclusions were not put to him in the hearing. Despite Mr. Pyaneandee's request, he was not provided with a transcript of his evidence to the hearing. In the Supreme Court, Mr. Pyaneandee's application for judicial review was dismissed. The court held that the comments impugned by Mr. Pyaneandee were not, quote-unquote, findings, and therefore not amenable to being reviewed. And further, without the transcript before the court, concluded that even if the passages were amenable to judicial review, there were no issues of procedural fairness with the evidence. Mr. Pyaneandee then appealed to the Judicial Committee, which is where we pick up the case. For the board, my Lady Similar, began by emphasizing the duties of candor and disclosure which public authorities have in judicial review proceedings. Her Ladyship pointed to long lines of authority that, in the words of the then Master of the Rolls, Sir John Donaldson, a public authority must go above and beyond normal civil discourse and, quote, put all cards face upwards on the table. These are continuing duties, applying at all stages of the proceedings, and yet, as Her Ladyship noted, counsel for the Mauritian authorities were instructed to refuse to answer various factual questions posed by the board. tactful and typical judicial understatement, Lady Simler said that the board regrets the failure by the respondents to assist the board in this way. Her ladyship was also critical of the fact that the Supreme Court had failed to order production of the transcript of the inquiry's hearing, when the respondents had failed to produce it despite their duty of candor. Having made clear the board's displeasure with the failures of candor by the respondents, Lady Simler then rejected the findings and operations dichotomy promulgated by the Supreme Court. The relevant consideration was if the fair-minded and detached reader would view the passage in the report, taken as a whole, as adverse to an individual's reputation. If this first prong were met, then the individual can judicially review the inquiry on the standard grounds or for breach of the principles of natural justice. According to this approach, the passages in the report, findings or not, were clearly amenable to judicial review. This led to the question of if the Commission had breached the principles of natural justice, was the idea that the allegations need to be put to the person accused? Now, Her Ladyship noted that the Commission needed, if it was going to be so specific in its allegations, to give the relevant documents to Monsieur Pyaneandee, or, if it took a more balanced tone, to at least give the gist of the applications. The board was very careful to specify there was no obligation to hand over the full policing files to Mr. Pyaneandee, nor to give in to the appellant's request for complex cross-examination, which would be a waste of resources. The relevant and crucial point is that the Commission's procedure did not fully present the allegations, not that the Commission had to provide specific documents or engage in specific procedural manner of going about things. It is, after all, fundamentally and statutorily, the job of the Commission to set its own procedure. Consequently, their Lordships' board allowed the appeal, ordering various passages to be struck and replaced, in digital copies anyway, by a reference to the board's opinion. This case presents an opportunity to consider the question of tension between the efficiency and efficacy of an inquiry and procedural fairness. Those who follow my writing may know that I've written critically in the way in which concerns over procedural fairness have turned British public inquiries into extraordinarily lengthy and complex affairs that cost far too much, reward lawyers at the expense of everyone else, and are forced to consider voluminous arguments and evidence for so long that by the time the conclusions arrive, they are too late to be of any use. And listeners in the United Kingdom may have noticed this recently with the cavalcade of KCs and various motions and claims during the pending inquiry into the deaths of babies at the Countess of Chester Hospital, chaired by my Lady Justice Thirlwall, and examining the events leading up to the alleged murder of those babies by Lucy Letby. In all of this context, it is absolutely crucial to emphasize what the board did and did not say. The board's decision here, quite happily and sensibly, is not one that forces more complexity on inquiries, which is the last thing they need. Instead, quite commendably, Lady Simler, at various points, emphasized that the Commission could have simply provided gists of allegations, had no obligation to hand over massive files, and had control over its own procedure, and no obligation for full cross-examination as if it were a trial. An inquiry into drug trafficking in the entire country of Mauritius has to do a lot of inquiring. Cannot be expected to spend days on hearings for one person. Rather, the board's criticism was that the commission had prejudged the matter and made allegations which were very damaging and phrased with absolute certainty rather than any qualification. This failed to show the basic care one expects of an inquiry. Ironically, the Commission's procedure of a hearing, where allegations weren't properly presented, was far worse than simply sending a questionnaire to the appellant by post. Thus, the takeaway from this case is that a reasonable inquiry can be procedurally streamlined while being insulated from judicial review of its findings. A competently run inquiry, rather than one operating in the rogue and bizarre manner of the one in the case at bar, or the endless and pointless operation of public inquiries in the United Kingdom, can easily respect natural justice while avoiding the long sort of hearings that drag down the important work of an inquiry, which is to make broad findings about society. Finally, I want to briefly touch on the failure of the Mauritian authorities to cooperate with the board. As the board said, the duty of candor on public authorities is very strong in this sort of judicial review proceeding, and it is disturbing. The respondents instead instructed their counsel to refuse to assist the board. The Privy Council, sitting quite a long way away from Mauritius, requires parties to provide it with the relevant records and information so that the work of the board can proceed in the best possible way. I can only hope that the, frankly, shocking decision to instruct counsel to refuse to provide certain information to the board is a one-off mistake and not the sign of a new and dangerous trend. Well, thank you very much for listening to another episode of In the Privy Council blog, brought to you by the Legal Style blog. I have been your host, Elijah Granite. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleBlog. You can also read an article I mentioned earlier on public inquiries by clicking the link in the show notes. If you have any comments, questions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and remember, l'oratoire il Maurice.
It ain't well to do the other thing.